Hello, ladies and gentlemen. This is my presentation of the People versus Joseph Bentley. Slide 1. The defendant and appellant, Joseph Bentley, was convicted of the first-degree murder of Alvin Green and the attempted willful, deliberate, and premeditated murders of Lennis Johnson, Jason Payne, and Devin Brown in a gang-related shooting in 2002. The incident occurred when the appellant and the co-defendant accosted members of a rival gang at a shopping center parking lot. Green, Johnson, Payne, and Brown then attempted to escape from the defendant and co-defendant in their vehicle, after which the appellant and co-defendant promptly followed to intercept them. Bentley was the driver, and the co-defendant was in the passenger seat when they drove beside the vehicle, into which the co-defendant fired 25 to 30 shots from a firearm into the victim's car, killing 1 and injuring 3. Next slide. In his trial in a criminal court, the appellant was convicted of one count of first-degree murder and 3 counts of attempted murder for piloting the vehicle out of which the co-defendant fired the shots that killed and wounded the victims. The jury in People v. Bentley also found true a special circumstance allegation that the murder was intentional, intended to inflict death. Although the appellant was not the shooter, natural and probable causes doctrine allowed him to be charged with first-degree murder as an accessory to the crime. Next slide. In 2019, SB 1437 was passed in the California Senate. Otherwise known as the Best Practices Act, this bipartisan bill amended California's century-old felony murder rule. The felony murder rule said that if death occurs during the commission of certain felonies such as robbery, the suspect must be charged with murder whether or not they had intended to kill or aid to kill. The appellant in this case thought it might be worth a shot to petition the court for resentencing because he was charged for murder although not having been the one assaulting with a deadly weapon. It's under these circumstances that the appellant was eligible to petition the court for resentencing under Section 1170.90 of the California Penal Code. This is why the trial court appointed the appellant counsel and set the date for the hearing. Next slide. This is what the court found. The prosecutor was immediately opposed to the petition of the appellant, insisting that Bentley was ineligible for resentencing, and the judges agreed. The appellant's petition for resentencing was summarily denied. The following codes and cases were cited as the grounds for dismissal of the appellant's petition for resentencing under 11790 of the California Penal Code. These are the cases and enacted law that were most important in their decision. People v. Jenkins, People v. Rodriguez, California Penal Code subsection 188 and 189, and the natural and probable causes doctrine, which I believe we're going to start with. Yes, natural and probable causes doctrine, as defined by Merriam-Webster, is a consequence that one could reasonably expect to result from an act determined to be a natural and probable consequence of the defendant's negligence. The appellant was convicted of first-degree murder under this doctrine, seeing as how he willfully pursued rival gang members who were trying to escape. So the natural and probable causes doctrine is, I guess it would be just a sort of legal policy, sort of like caveat emptor. Next slide. In the case law, two specific cases were cited, which established the authority of the trial court to dismiss his petition, of which was appealed in this particular case. People v. Jenkins said that the trial court has broad discretion to determine whether good cause exists to continue a hearing date, and People v. Rodriguez states that whereas here a discretionary power statutorily vested in trial court, it is the exercise of that discretion that must not be disturbed on appeal except on showing that the court exercised in its discretion in an arbitrary, capricious, or patently absurd manner that resulted in manifest miscarriage of justice. Pretty specific. And summarizing those two examples of the case law that the judge used in his decision, they established that the court had broad discretionary power to start with, that is limited to very specific parameters, and that if the original People v. Bentley were a travesty of justice, it would automatically have standing in the Court of Appeals. That jury trial was conducted with no errors, so the discretion of the court of origin held fast in the appellate judge's decision. Next slide. So from the California Penal Code is where the judges draw the substance, what I feel is the substantive application of the law with these rules. So the first one is California Penal Code 188. Most important of note is Section A2, that malice is implied when no considerable provocation appears, or when the circumstances, underline is malice is implied when no considerable provocation appears. So my analysis was that established that the appellant acted with malice when he chose to chase the rival gang members, disqualifying the notion that the victim's death was an unforeseen event, therefore qualifying him for the new petition for resentencing under SB 1437. Then there's California Penal Code subsection 189, specifically section E2, where the person was not the actual killer, but with the intent to kill, aided, abetted, counseled, commanded, induced, solicited, requested, or assisted the actual killer in the commission of the murder in the first degree. So these two California penal codes were released almost concurrently with SB 1437 in anticipation of people sort of trying to work around, in a constructivist sense, what the definition of first-degree murder is. And these two California Penal Code subsections basically maintain what the court's definition of murder in the first degree is. Next slide. I'm sorry. Here's the analysis that I penned of the court's utilization of California Penal Code subsection 189. Considering the facts, the appellant was not wrongly sentenced for first-degree murder, precluding any notion of mistrial and disqualifying the appellant petition for resentencing under section 1170.90 of the California Penal Code because he was an active participant in the murder rather than an unwitting interloper to the crime. Next slide. To summarize the case, the passage of SB 1437 was enacted to address deficiencies in the age-old felony murder rule that was disproportionately affecting youth of color and women. The appellant's crimes, however, were heinous enough in nature to not be subject to this enacted law's scope. That was the purpose of enacting California Penal Codes subsection 188 and 189 to make sure that those that commit the most senseless and violent crimes are still held accountable, while the law evolves to be more equitable in a changing society. And of course, there's an epilogue which really sort of establishes a human element to the judges that ruled in the case. The appellant made a choice in 2002 to engage in a vehicular pursuit of rival gang members. This allowed his co-defendant to shoot at the fleeing rival gang members. The jury expressly found that he did so with the intent to kill. The legislature did not intend that the appellant should have levity. Appellant is fortunate that the co-defendant was a poor shot. Had he killed one other gang rival, appellant would have been facing the death penalty. And thank you. That is the end of my presentation. Have a great day.